Well, now that the Seventh Circuit U.S. Court of Appeals has the case of the challenging of Illinois' gun and magazine ban in their hands, they took it under advisement after hearing it yesterday for 90 minutes. What does it mean? What does all this spell for what we could anticipate seeing come forward from the Seventh Circuit U.S. Court of Appeals? This is Illinois in Focus Daily. I'm Greg Bishop with you each and every weekday morning. Let's connect now with Todd Vandermyde. He is president of the Aurora Sportsman's Club, a former gun rights lobbyist at the state capitol, also somebody who advocates for gun rights at the state capitol still to this day, showing up at legislative hearings and such, and I appreciate him taking the time this morning. Tell us what you heard, what you saw yesterday in the Seventh Circuit Court of Appeals, Todd. Thanks for joining us. Oh, hold on a second. I apologize. I even checked the microphone before we went live, and I didn't turn your mic back on. Go ahead.
That's fine, Greg. Great to be here. So we prepped for what we thought was going to be a bare knuckles brawl like when we were there 2 years ago. But it became clear when Judge Easterbrook did not say anything for almost 17 minutes into the hearing, letting the state just ramble away, that it didn't appear that he knew if he had a friend on the court and he could bluster his way for everything. I don't know. We went in there expecting to lose. We walked out of there with hope that, that St. Eve was being reasonable and honest in her questions. She certainly was harder on her questions to the state than she was to our side, although I think she's still a bit confused about how to apply Heller, Bruin, and the like. But it was a very different hearing than what we saw 2 years ago.
Well, and if you could kind of delve a bit more into the characterization of the questions you heard from St. Eve, because she did have multiple tough questions to the state. How do you characterize those, comparing, what she gave to the state side, to Murphy, to even Dillon at the tail end from the DOJ?
Well, the state seemed to be grasping at some straws in trying to figure out a way to either get this case rolled back or, you heard them talk about error or erroneousness, de novo review, remanding it back because Judge Easterbrook thought they didn't answer a question. And there was first 10, 15 minutes was between Brennan and St. Eve going to the state because the state was just saying the lower court got it wrong. The lower court got it wrong. And hoping that if they said that often enough that it would just become magically true. And St. Eve was pressing them on the technicalities of those standards that, then aren't you having us do the fact finding and substituting our thoughts for what the trial court did in the trial and all that. So there's that whole part of it. And it was very, very different than the question, Erin Murphy, and kudos to Erin for the job she did standing up there. People will always Monday morning quarterback how certain attorneys do. And I will, on this case, if you're not the one standing up there getting peppered, having to argue, the standard of review, what, the rules are around erroneous findings by the lower court, not to mention all the technical nature of firearms and 4 Supreme Court decisions. It takes a little bit to do all that. And if you miss something here or there, I know that when I testified in front of committees, I would beat myself up. I forgot to say something. But here, the St. Eve came back to, our side and said, well, what about these mass shootings? And, Erin got there and did, and just pushed back on it. Just like, and it was more of a touchy-feely thing from St. Eve where, I think a short answer is now you're back to interest balancing. And they did that earlier with the state's play where they were trying to ask some questions. And, the state was, without saying it, asking for interest balancing all over, which has been verboten by the Supreme Court. So I'm heartened. I don't. Brennan's clearly on our side. He wrote a dissent against the last opinion. St. Eve replaced Wood, as you acknowledged earlier. So the question is, St. Eve has had a string of anti-gun rulings. What does she do in this one? Because she studied the record. There was a record, and Brennan made a lot about the record. So, and when Easterbrook tried to, well, they didn't do this. Aaron pushed back and said, "Hey, footnote 22, it's right there. It may not be in the format you like, but it's there. We put it into the record. We built the record." And I think that Judge Easterbrook's Hail Mary on a, remand question because he didn't get it the way he wants it is just that. I think it's a Hail Mary to try to slow down what he doesn't see is that his view is prevailing overwhelmingly at this stage.
Todd, we've of course, have no idea when they're going to release their opinion. It could be weeks, could be months. It took them a good substantial amount of time to even just announce when they're going to be accepting briefs in the case in the appeals court, let alone setting the oral arguments date. But now that that's in the can here, how do we see this proceeding forward? Is it going to be a while before we get to a ruling on this and possibly up to the next steps to the U.S. Supreme Court?
That depends on a couple of things. One thing is that, the seventh is quicker than a lot of other courts in terms of, turning out decisions. Um, but it depends on which way it goes. The quickest way to the Supreme Court is for a 2-1 ruling against us. That puts us in control of the case, and we're in the driver's seat. We're the ones petitioning the court. And if that were to happen sooner rather than later, I mean, we don't like to lose, but in this instance, losing would be the fastest route to the Supreme Court. They could remand if Judge Easterbrook gets his hooks in the St. Eve and say, "Yeah, we want some more information," which will push us back down to the trial court and delay things. We could get a win, in which case I would wager that the state would seek an en banc review by the full court as to what the district court did and what this 3-judge panel came to a conclusion on. And then the question is, they have a certain amount of time for them to have the vote, which is usually about 2 weeks, and whether they take it. If they take it, that's going to drag it out longer. If they deny it, then the question is, will the state appeal this? Remember, when Madigan lost the Kerry case in 13, that she did not appeal it to the Supreme Court. And the thinking is that we were the last state. If they took it to the Supreme Court and the court took the case, then they lost the country on the Kerry issue. Instead, we had to wait till 2022, almost another decade, to get the Bruin decision. So if they lose one here, I think they may not appeal it, that they would want to prolong things. They've lost Illinois. We're the only state in the Seventh Circuit that has a ban like this, and it would give them time to try to figure out what's going to happen with the other circuits. Those are just some of the back of the napkin kind of.
Yeah,
I mean, you need a Ouija board, dude. You really do.
Some of the, yeah, or one of those whiteboards with strings attached to everything. I kind of want to touch on something here just briefly with the questions that I heard primarily from Easterbrook was all about what the district court didn't do that Easterbrook said they told him to do, and Brennan really seeming to kind of counter that, saying this is a pretty strong record. It's the first district court case where we've had this type of record, 4-day bench trial, thousands of pages, and expert testimony from both sides. It's an uphill battle for the state, Brennan said.
Yeah, I agree, because Brennan gets the test. The test is, does the text cover the conduct? If the answer is yes, it is now the burden on the state to prove that the law or regulation they are trying to uphold has a consistency in history and is, found within the history of what we've been doing, and that the laws that they point to as analogous, the how and the why are for the same purpose. And Brennan was not buying that from the state. He gets the test. He showed up. He was not this vocal 2 years ago. He was very vocal yesterday, and it was a welcome sight. It felt like I was in a different courtroom.
Todd, finally here, I know it's hard to prognosticate what you think the outcome's going to be, and you kind of gave us all of the back of the napkin calculations and such, but what do you think's going to happen with this case? Which way is this going to go? What's your gut feeling?
I don't know. I was with a couple of the lawyers that dealt with this. I was with some other guys that have been involved in the case, and we all kind of came to the conclusion that it's 50-50 on a crapshoot, and it all centers around what does St. Eve do? Do we get a remand because they want a little more and Easterbrook convinces her to do that? Do we get a split decision? ARs are protected, magazines not so. That puts us into a whole nother quandary about how to appeal that kind of stuff. And we don't know if the court is going to sit on this, waiting to see what happens with Duncan or one of the other cases that's pending at the Supreme Court. So, this thing is just, but we all get the feeling that this is the case the Supreme Court wants because of the record that was built. And remember, Thomas took a shot at them and said if the Seventh Circuit is going to ban the most popular rifle in the country, then it's our duty to take this up. So, whether or not St. Eve, I mean, I was involved in a amici brief for the Second Amendment Defense and Education Coalition, to where we took all the prior statements from the Supreme Court justices and put it down to say they've pretty much telegraphed what we think is going to happen, and you people should be listening to this. So whether or not that makes an impression or not, I don't know, but we certainly tried to get the arguments in front of them.
Todd, finally here, if you could encapsulate what you're hearing from your fellow gun rights advocates and fellow gun owners. I mean, you're the president of the Aurora Sportsman's Club. I was at the zombie shoot this year. Hundreds of people out there shooting all kinds of different firearms, from muzzle loaders to cowboy guns to even artillery, launching cannonballs 500 feet into the air, it looked like. What do you think the message from gun owners in Illinois is to this law and to the Democrats who keep pushing this?
I think the lion's share of gun owners are flipping the middle finger to the governor and the legislature about what they did. And they've pushed a lot of gun owners to a point to where they no longer care what the legislature has to say. They've just enveloped that much contempt for the conduct they're conducting in trampling our rights. With that, gun owners, they're cautious, they're quiet. You don't see some people putting as many videos or photographs or stuff in social media, but for the most part, this is an annoyance. They believe it's wrong. It is a pain in the ass to deal with in certain ways, but we're out at the club. We're knocking on 3,000 members. We've got a membership drive going on. People are signing up. So they haven't scared away the gun owners. And if anything, they've just, made them dig their heels in harder.
Todd, we'll obviously be talking more about this in the weeks and possibly months to come to see what the outcome's going to be in the case challenging Illinois' gun and magazine ban. But I always do appreciate you being able to take the time with us when we can do it live. So we'll obviously talk again very soon. All right.
Take care.
It is Illinois in Focus Daily. I'm Greg Bishop with you each and every weekday morning here with the Center Square. You can find the podcast where you get podcasts. Go to thecentersquare.com for headlines. Get those free in your inbox at thecentersquare.com. Just click newsletter, sign up for it, and you'll get the headlines. But again, we go live here with Illinois in Focus daily on the Center Square's YouTube page each and every weekday morning at about 8 o'clock. Tons of people tuning in this morning. It was great to see that. And obviously, there's a lot of interest in the gun and magazine ban challenge. So we'll continue to cover that for you here with Illinois in Focus daily.